my statement is written and just the call to the prosecution.
I think that this loss is a setback for Raila Odinga.
What policy recommendations were fronted by the candidate?
With diversity, we demystify important legal issues locally, regionally, and internationally.
What Tanzanians.
Join me, Elvin Onsongo, as I bring you more insights on law matters.
We are looking at social issues. What is the problem? Is it the economy? Is it...
Law Matters Show, creating awareness, advocacy, and enhancing lives.
This program is rated GE. Content carried in here is suitable for general family viewing.
A very good evening to all our viewers and welcome to Law Matters, the program or the show that will always put into context all legal concepts in order to address your views, reviews, and to answer to your candid questions. Now, I am your host, Elvin Onsongo, and do not forget to keep interacting with us. We are live on KUTV, and we are also live on all our social media platforms, that is on YouTube at KUTV Live, on Instagram at KUTV_Kenya, and on Twitter, now X, at KUTV Kenya. Happy Katiba Day, or rather happy Constitutional Day that was held. This is belated Katiba Day that was held on the 27th of August 2025, and this was in order to commemorate and remember the promulgation of our Constitution 2010. In that new constitution, you remember we have a very robust chapter 4 on the fundamental freedoms and fundamental rights to all citizens. Among them is Article 31 that provides for the fundamental right to privacy or the right to privacy. This involves, among very many things, privacy to information. That is the reason why tonight we look at the data protection in Kenya, the legal and regulatory frameworks around data protection in Kenya vis-a-vis or in connection to the now newly developed artificial intelligence, otherwise known as AI. Tonight, I'm not alone. I'm privileged to have an expert in technology, an expert in technology law. I will not introduce her, so before we delve into this topic, I will let her to introduce herself. Welcome.
Thank you so much, Nsongo. My name is Nancy Kisangao. I am an advocate of the High Court, and I am a compliance specialist specializing in privacy and technology law. I have worked for the last 4 years in various international and national and governmental organizations in looking at compliance in terms of the right to privacy, looking at the Data Protection Act and seeing what can we do to ensure that, one, the citizenry and the data subject understands their rights, and also when we are having organizations that are processing data, to understand what obligations those organizations have with respect to the data that they are holding. So I have worked as an advocate, obviously advising clients in a personal and private capacity. I've also worked with IAVI most recently, where we were working with clinical trials and trying to understand how we ensure compliance from a data protection perspective when it comes to clinical trials. I am currently a managing partner at my law firm, Kisangao and Co-Advocates, and we specialize in technology law and just driving compliance for organizations. Thank you so much for having me here.
Asante sana Wakili Nancy Kisangao, and welcome to Law Matters.
Thank you.
This is the mother of all law talk shows in Kenya. And also a very big welcome to the law students, Kenyatta University, for the very first time, who are going to be part of our audience tonight and who are going to shoot their questions at the very tail end of the show. Karibu sana. Thank you. Now, Wakili Nancy.
Yes.
We're talking about data protection and the interplay, the relationship between data protection and artificial intelligence. Why are we talking about this? Why are we here? How did we get ourselves into this discussion?
So thank you very much. So we're going to talk about it in two separate concepts. First, we're going to talk about data protection. And as you mentioned rightfully, Happy Katiba Day, though belated. And that is the fundamental segment where we get our rights to privacy. And when you look at the Data Protection Act, it's actually an extension of that specific article in the Constitution. And it is meant to ensure that we have a way to operationalize that right to privacy. So we're talking about what does it mean when you're talking about personal data? Who does it relate to? Who is the subject of this personal data? Who can go to court or to now rightfully the Office of the Data Protection Commissioner, which was established under the Data Protection Act, to seek, say, if you're having a complaint, if you need to get guidance as an institution, where can you go to get recompense? And when you talk about the rights to privacy, that is the fundamental and the reason why we're talking about data protection, because the Act is just an extension of that. Then when you're talking about artificial intelligence, I think the best place to start with will be the experience that we have had as a country and globally from the COVID pandemic. During COVID-19, we had a global shutdown. People could not go to places where they normally frequent. If you're working, then you couldn't go to work. You had to work from home. You had a lot of directives directing people to stay at home, to work from home. And we had a technological shift where we had a lot of reliance on cloud computing applications. And we're talking about the cloud, we're talking about being able to work remotely, being able to save your files, on your device and then continue working, as opposed to going physically to a room where you have a server and having those documents stored there. And if you need to access them, accessing them from a server that was located in an organization and in a building. So that is where we come, and you have this interplay of artificial intelligence. From that period, that is post-2020, we had a lot of applications trying to ensure we have a leaner structure when it comes to applications. So you're not talking about having an entire room that is dedicated to servers. We're talking about being able to just upload something on your virtual drive, and then being able to send that across for work. So when you're talking about where we are at now, we have come from an instance where we have a lot of applications. Recently people have been talking about ChatGPT, but if we move, further, we had the instance of WorldCoin, where many people were lining up so that they can get their retina scanned for the purposes of, receiving tokens that were virtual cash. And the reason why we were having such a huge rush of people moving to do so is because WorldCoin essentially wanted to create a product where you could have digital proof of physical identity. So that is where the interplay comes in. We are moving at a fast pace in terms of technological inventions. I think now if you think about ChatGPT, we are on version 5, but there are more and more applications that are coming out every day that are using artificial intelligence. And those applications are really founded on the use of data, whether it is personal data or actual other data, such as financial data of companies. So we're talking about artificial intelligence heavily relying on the use of personal data for the purposes of developing the applications.
Thank you, Wakili. And I think, as you've rightly put it, these versions of ChatGPTs and technology and other digital spaces very soon, I know technology is very dynamic,
yes,
and we may move to 6, 7, 8 very soon. Now, for the benefit of somebody who is watching us and for the students who are with us, what is data protection and why is it essential? Why is it critical to have data protection?
So, as you rightfully mentioned, we have the Constitution that guarantees the right to privacy. And when you look at the formulation of what the right to privacy talks about, we're talking about ensuring that your personal affairs, your communications with other people are not infringed with by any third party, even the government, without having specific rules and regulations around that. So what the Data Protection Act does, it sits down and defines and codifies what is personal data. And what does it mean? When you're talking about personal data, you're talking about data that can either directly identify you, so your name, for instance, or indirectly identify you. So think about your ID, because without having a place where we have stored information saying that ID 12345 is Charles X, then you cannot really directly identify a person. So what the Data Protection Act does, it first codifies what is personal data, and it ties it to the fact that you can either directly identify a person or indirectly identify a person. So that is what the Data Protection Act does. It just sits down and says, this is the information that we consider to be personal, and this is the information that we say is now governed, and now the right to privacy applies to it. So that is personal data.
Okay.
Yes.
Does personal data take into account sensitive information?
Yes.
Talk about it.
So when you come to personal data, you find that is the first qualifier. We're talking about personal data just broadly, that it can identify a person directly or indirectly. And then you come to the question of sensitive personal data. And this is specific information that deserves higher protection when it comes to the Data Protection Act. When you go through the Act, you realize that there are things that you cannot do in terms of collecting that data without having met certain qualifiers. For instance, you cannot process someone's biometrics, someone's fingerprints, someone's health data, someone's financial data without having obtained specific consent to that data, so that you can, if you're trying to process, for instance, my fingerprints, it has to be very explicit to me that you're going to process my fingerprints for this purpose, for this reason, you're going to store them for this amount of time. So the categorization of sensitive personal data is a higher specific categorization that is under the Data Protection Act. And what it literally translates is that this category of information deserves higher protection when it comes to processing it by a third party or even by a person who's collecting it from you.
Thank you very much. Now, away from, or rather in addition to the Constitution and the Data Protection Act of 2019, take us through what are the other legal legislative framework or pieces of legislation or laws that govern data protection vis-a-vis artificial intelligence in Kenya. What are the other additional pieces of legislations that come into play?
So it's very critical to note that currently, as we are, Kenya does not have a specific piece of legislation that relates to artificial intelligence. So we have specific provisions in the Data Protection Act. When you look at, say, Section 36, that relates to automated decision making. So automated decision making means that I am using a specific code, a specific program to make decisions about you without tying in a human being. So I think the best example I can give is if you have ever gone to the bank to get a facility, if you've ever used a mobile loan app, they always score you in terms of your credit to see, are you repaying your debt or aren't you repaying your debt? And based on that score that they're going to get, that will govern the loan terms that you're going to get. So in most cases, you'll find that they will have a written program to automatically do this, because it takes a lot of time for me to sit down and consolidate this information from different credit bureaus. So automated decision making basically means I am using this program that I have written and I have also coded in some language or instructions based on amounts of data that I've fed into it to say, if X applies for this facility and they have gotten, say, loans in 10 other different people, then I won't either give them this facility or I'll give them this facility at a higher rate. That is what automated decision making looks like. So that is the only specific provision that we have in the Data Protection Act that goes to the extent of governing artificial intelligence. But when you look at it from a broader policy perspective, then there are different policies that have been set in Kenya and internationally to govern artificial intelligence. So I think the most we can begin is, foundationally, we begin with the National ICT Policy. This is an ICT policy that was published in 2019, and that set the framework for any artificial intelligence programs that we're going to have. And the reason we say this is it is not explicit that if you go and look at the ICT policy, you're going to find a specific reference to artificial intelligence. But when you look at the policy, you're going to find provisions that have been made about the core fundamentals that are required before you can have an artificial intelligence program. And this is things like broadband access. You remember we used to, I think if you are as old as I am, we remember having fiber landing.
Maybe older.
We remember having fiber optic cables landing in Kenya, and it was actually a huge news item. So when you think about the National ICT Policy of 2019, we're thinking about fiber landing in Kenya, having infrastructure that is required for us to actually say we can operationalize artificial intelligence programs. Then when you move from that, from a continental perspective, we had the AU the AU African Union Continental Artificial Intelligence Strategy, and that basically sat down and said we need to be able to look at to sit as a country and as countries and have a framework of saying this is how we're going to deploy and implement artificial intelligence programs. But also in addition to that, we need to deploy artificial intelligence programs in a manner that befits Africans. And when you think about it from a global perspectives, there have been conversations going around and saying we're having artificial intelligence programs, but we're talking about ChatGPT that is operated by OpenAI. That's a company in the United States, but you do not have Kenyan-owned, Kenyan-made artificial intelligence programs. So the AU artificial intelligence strategy is sitting down and saying, as states, as member states, what are the things that we can do to ensure that if we are having artificial intelligence programs, we're having programs that are built on African data, that are built on African policies, and that befit African people. Then moving on back, now coming back to Kenya, there are other two more recent policies that are more crucial for us. And the first one will be there's a Kenya National Digital Management Policy. And that's a policy that was passed in 2022. It's a 2022 to 2032 program that seeks to sit down and say, what are the things that we need to do to ensure that we are internet ready, that we are artificial intelligence ready. And here you're looking at digital skills that are required. So can we assess as a country and say we have this level of skill set that can operationalize artificial intelligence? Does the population, so does Mama Mboga understand when you're talking about artificial intelligence, so that they're not really knocked out when you're talking about implementing this large-scale program, maybe from even a governmental perspective? And I think it's actually something you can even check out, because currently when we come back closer to data protection, the Office of the Data Protection Commissioner has actually established a Linda Data chat box that you can sit and you can go to the website and say, I need to do XYZ, can you guide me? And the beauty of it is that it is based on African experiences and African legislations. So it's easier for you to actually interact with it, even as low as I do not have enough education skills to actually understand what data protection is. So that is the whole segment. And then now, most recently, as late as March 2025, we have a Kenya Artificial Intelligence Strategy, and that actually now forms the basis of what implementation will look like going forward, because it goes down to say that yes, we do not have an act, but these are the legislations that we have surrounding not only just artificial intelligence but technology as a whole. So it goes down to talking about the various specific legislation other than the Data Protection Act.
Thank you, Wakili Nancy. I hope the so-called AI strategy in Kenya finds itself into our legislative books for proper regulation of AI use in Kenya. Yes, that is still our expert in data protection, Nancy, Wakili Nancy Kisangau, taking us across borders, talking about regulations of AI use in Kenya, outside Kenya, and even internationally. The reasons more why we say this show is the mother of all law talk shows. To remind our students, keep preparing your questions. As we will come to that final segment, we will be taking your questions from you. And also our viewers, Keep interacting with us. We are live on Instagram at KUTV_Kenya. We are live on Twitter at KUTV Kenya. Now, Wakili, you've broadly talked about the Data Protection Act 2019. A brief overview of that legislation, I looked at Section 25, provides for principles that come into play when data protection aspect comes into a perspective. Kindly address yourself into the principles of data protection.
So there are about 7 principles that govern data protection. And I think for the students here, the role is normally, once you understand the principles, you understand everything about data protection in Kenya at least, and even just globally. So there are various principles that govern data protection, and these principles include first having the principle of transparency. And transparency just means that the data protection subject understands and can know why and how you're going to be using this data. Remember, when you're talking about Data Protection Act, for you to process data, there are 2 ways you can go about it. You can go about it through consent. That means you have gone to the data subject and explicitly asked for consent for them to process, for you to process this data. Or you can go through a second route, that is the route of necessity. So for necessity, it means that there's a specific need as to why you're processing this data. So for instance, either you have a contract that you want to process, maybe you've entered into a contract, maybe you want to use Facebook, for instance, so that means then you're going to be subject to those regulations and the terms and conditions, and as well as the privacy policy that Facebook has. For instance, maybe I have bought something from you and you need to process my ID for the purposes of just ensuring that I am the person who's purchasing that item from you. Then there is an element of maybe I'm doing this subject to a specific law or regulation. So for instance, when you go to a bank and you need to open an account, they're always going to ask you for this information. They're going to ask you for your KRA PIN. They're going to ask you for a couple of details to ensure that they're complying with the anti-money laundering legislations. So when you think about it in terms of transparency, the principle is basically asking you, can you tell the data subject why you're processing this data? And the easiest way to go about it is normally through a privacy notice. And the privacy notice says that we are going to process your data for the following reasons. We are going to process it, we are going to store it in the following places. We are going to share it with the following people. When it comes to artificial intelligence, it can become a bit tricky because, for instance, if you're using a chat box, you're just going to say, they're going to tell you, oh, just sign and just check into this box. And then now we're going to be able to, answer any questions that you have. But it becomes very important for you to sit down and actually read through that notice and say, this is what they mean when they're saying they're going to process my data. I think you will notice, if you've been keeping up with the news most recently, a lot of countries, so South Korea and even Italy, have been banning the use and actually the publication of personal data on ChatGPT. And there have been also restrictions on how it can actually operate within their country because they do not want to have this form of unlicensed processing of personal data relating to their civilians. So when you're talking about the principle of transparency, and even more so when it comes to artificial intelligence, you're really talking about ensuring that the end user understands how you're processing this information. When it comes to a technical perspective, there are instances, if you're a developer and you're trying to now comply with this provision, there are ways you can do it. So for instance, you can have something we call a layered privacy notice. And basically, if you've been using something like Google, you understand that when you're trying to sign up on Google, they say, we are going to be using information like this. But if that is only limited to your email, when you go to YouTube, they tell you, okay, now you've moved to this platform, then this is how you're going to be publishing or using your information.
Thank you, Nancy. We will pick it up from there. I believe we want to talk about the developers, the data controllers,
Yes.
and processes.
Yes.
Directed by my very able director, Mr. Boniface Odhiambo, that we take our very first break. But when we come back, you pick it up from where we have stopped. Thank you very much, and thank you, our viewers. Continue watching us and do not move. See you right after this short break.
Are you an aspiring media practitioner, a graduate, or you just want to advance your skills in television production? Then welcome to Kenyatta University, where education meets innovation. KUTV, the premier university television station in Kenya, is now offering short courses in TV studio, field technical operations, and video editing. Through these courses, you will acquire hands-on skills on camera operations, media production, lighting techniques, audiovisual editing, and sound and visual control, and how to operate key equipment in modern TV control room. Enroll today at KUTV and discover your full potential in cutting-edge TV broadcasting. Graduates of these courses will receive professional certificates. For more information, visit our offices at KUTV Studios or call us on 020-870-4252 or 020-870-4255 or SMS us on 0739-110-544. KUTV, a new experience.
And welcome back to Law Matters, the show that will always put into context all legal concepts in order to address your views, reviews, and provide adequate and proper answers to your very candid questions. With us tonight, we are still privileged to have our expert, Counsel Nancy Kisangau, who is giving proper voice to data protection in Kenya vis-a-vis the new invention, vis-a-vis the development of artificial intelligence, and also she'll be telling us whether we need specific AI-shaped legislations in order to regulate proper use of artificial intelligence in Kenya. We left at the point where you were talking about the principles provided under Section 25 of the Data Protection Act, and I believe you've not exhausted yourself on that. You can pick it up from there.
So I'm going to just touch on, I think, 3 more principles before we just move on with respect to artificial intelligence. So one of the key fundamental principles that we need to think about is, one is accountability. So accountability basically means that as a data controller or a data processor, you have to be able to demonstrate to the regulatory authority. So in this case, you're thinking about the Office of the Data Protection Commissioner, that you have complied at all times with the provisions of the Data Protection Act. And just for clarity, when you're talking about data processors and data controllers, for those who are not familiar with the Act, we're talking about the people and the individuals who are going to be processing personal data. For the controllers, they determine why are you processing this data, and then for the processors, they carry out that processing on behalf of the controllers. So when you talk about accountability, is that you have to be able to demonstrate to the ODPC every single time, at any point in time, that you have complied with the provisions of the Act. And the reason why it is critical is, other than just preventing you from having a lawsuit and being the face of breaking news tomorrow that you have a claim of 10 million that you need to pay someone, it is also very good for you because it enables you to demonstrate that at any point in time you have respected the rights of the data subjects. So to do this, you can do this in various ways. So there are prescribed ways under the Act. So the first thing is that you need to have a privacy policy. This is a document that is facing internally for your company, for your organization, that tells your employees how you handle information. Then there's a privacy notice that is externally facing, that's telling the people, the users of your product, how data is processed. So that is something that you need to have. The second thing that you need to have is agreements. So whenever you're sharing information with a third party, and in this case, I'm talking about if you're a company, if you're a developer and you have an application, what you need to ensure is that you have relevant agreements. So if you're sharing this with a third party, you need to have a data sharing agreement. If you're a developer and you're instructing a third party to process information on your behalf, you need to have a data processing agreement. Then it's also important, though not required, to have a record of your processing activities, to say that at any point in time, I can sit down and say, this is all the private personal data that I am processing, this is how it's been processed. Then it's important to have daily audits and annual audits and seeing how are you storing this information and what compliance measures have you put in place to ensure that that you do not have a breach, for instance. And if you have a breach, how are you communicating regularly with the regulator? So that is it when it goes to the principle of accountability. Then you also need to ensure that the data subject has full autonomy. So it's very important that to ensure that at any point in time you can demonstrate that the data subject has really understood why you're collecting their data, in what capacity, and how you're going to share that data. So those are the three principles I wanted to touch on. Now, when it comes to whether we need to have a specific artificial intelligence
Before we go into the specifics,
yes.
Still on the Act, the Data Protection Act, the data subject, according to that piece of legislation, is most importantly, it talks about a natural person.
Yes.
This is you, this is me. So does it mean a juristic person, for example, a company, data information that belongs to a company, which is not a natural person, is not protected pursuant to the provisions under that Act?
Yes, actually that is the case. And when you look at various jurisdictions, so for instance, in South Africa, under the Popeye Act, personal data also extends to a juristic person. But for the purposes of the Data Protection Act in Kenya, personal data only relates to a natural person. So this is you and me, humans, who their data relates to. So you cannot find a company saying that my personal data has been breached. You can find their directors saying that because they are human beings, to the extent that the director is a natural person, you can find a director saying that this personal data of mine has been breached. But you can find a company going to court and saying my data has been breached. If you're a company and you intend to protect your data, best of ways you can do this, you can do trade secrets, you can have non-disclosure agreements, but you can never have an instance where a company, insofar as the Kenyan Act relates to, is a personal data subject.
Thank you, Nancy.
Yes.
And also, you've talked about the establishment of the Office of the Data Protection Commissioner,
yes,
pursuant to that Act. Somebody is watching the show and he has a firm, he has a company, he has an organization, an industry, and perhaps they have not registered with the Office of the Data Protection Commissioner. Is it an offense under that Act to not be a registered party with that office? Does it attract a penalty, a sanction, if you are found out to carrying out businesses through any form of an entity and you've not registered with the Office of the Data Protection Commissioner?
So you need to be very clear. Registration with the Office of the Data Commissioner is only specific if you're processing personal data or if you're processing personal data on behalf of a third party, and that information relates to a person who's in Kenya or a Kenyan citizen, and they're not in Kenya. So that is the instance in which you will be required to register with the Act. Now, Section 18 requires it. It's mandatory, and it's an offense if you don't do it. I think there's a penalty for imprisonment and also a monetary penalty, but it is very important for you to do so. Because what happens is when you end up processing information that relates to a natural person, and you have a breach, when they are investigating you, the first offense they will find out is that first you're processing information without having the requisite licenses to actually process that information. And that becomes, even before you can even talk about whether you had a right to do so or a right not to do so, you're already in trouble. So it's very important for any organization, and even natural persons, if you're carrying out businesses as sole proprietor and you're processing information, you need to sit down and look at your activities and figure out, am I processing information insofar as it relates to the Data Protection Act? Am I keeping records of my customers? Am I texting them every other day and saying, hi, we have this discount? Am I sending, am I looking at their M-Pesa statements against this and trying to offer them a discount? So it's very important for businesses and entities and even sole proprietorships, because it's not that you need to be a company for you to be a data controller. It is as long as you are sitting down and processing information, another person's information, then at that point in time you need registration. And it's also important just to put a disclaimer to that. It's not all processing under the Act that requires registration. So for instance, if you're processing in the concept of household activities, I am processing this information in the comfort of my house, this is my information, so this is my ID, this is my bank account, then I do not need to now go and register with the Office of the Data Protection Commissioner.
Thank you, Nancy. Thank you very much. And just to keep reminding our viewers that keep interacting with us, send in your questions, your views, your reviews through our social media platforms on Instagram at KUTV_Kenya, on X at KUTV Kenya. And also to our students, do not forget to keep inking your questions, as we will give you a segment for that. Wakili, now where we are with the regulations, the legal framework that governs the use of AI in Kenya, what do you think? Do we need a sector-specific, or do we need specific AI legislations to mark proper use of AI in Kenya?
So I am of the opinion that we need a broad Artificial Intelligence Act. And the reason for this is that there are a lot of things about artificial intelligence that are not necessarily personal data protection. So there are things about artificial intelligence. For example, if you're thinking about who is going to be governed by this act, that does not fall within the purview of data protection, because it does not mean that just because a company is an artificial intelligence company does not mean that they're automatically processing personal data. They may be processing something else. They may be looking at all novels in Kenya and then paraphrasing them into local languages. That is not personal data protection. That's something quite different. But if it is a company that is not located in Kenya, but it is processing, oral tales from Kenya, that is not data protection. So you do need a broad Artificial Intelligence Act. But also, in addition to that, that act will have a ripple effect that will also affect how personal data is processed. We may even find that by the end of the day, once we have this broad act, then we do need to have a specific regulation that falls under the Data Protection Act that specifically speaks to data protection. Remember, currently as we speak, we already have a section in the Data Protection Act that talks to automated decision making. But what about other forms of processing? So, for example, when we had the WorldCoin case in Kenya, we had instances of biometric processing for the purposes of developing an artificial intelligence tool that can develop an online identity that can verify online identities. Now, in that case, you're talking about large-scale processing of eyes, iris scans, fingerprints. So when you're talking about governing artificial intelligence, we also need to have the act to talk about what can be done with artificial intelligence, what can't be done with artificial intelligence. And finally, the most important thing is, what are the ethics around this? Do we need to have a human being at the end of this at all times? Are there instances where we can say, this is fine, we can fully automate this. This is not fine. In these cases, we need to have a human being to make the final decision. So yes, we do need to have a specific Artificial Intelligence Act. I think by having that, we will be following the examples of very many countries who have gone before us. I think for the EU, they began their negotiations in 2021. And it's not an instant process. We can have time and time of review. We can have enough public participation. We can have specific sector engagements to sit down and discuss what we think needs to be in this act. So yes, we do need a standalone act, but that act can still have a ripple effect in the specific data protection regulation.
Thank you, Nancy. There's need for a standalone legislation.
Yes.
Thank you. Now, let's transit into practical implementation part of this discussion. You've taken us through the principles under Section 25 of the Act. And now, just tell us, how can we design AI systems to accommodate those principles enshrined under that section for proper use of the same? How can we design these systems in that environment of the principles under Section 25?
So when it comes to design, it's very critical to think about what does the Act talk about in terms of designing systems generally and ensuring that those systems are designed for the purposes of complying with the provisions of the Act. So the Data Protection Act provides that when you're designing something, you have to by default and by design, ensure that it complies with the principles under Section 25. So when you're talking about by design, it means that when you're coming up with a system, when you're coming up with, I want to have a chat box, you're sitting down and saying, if I'm going to have a chat box, it's going to get information, personal information from a person. Where is this information going to be stored? Is the end user going to understand that this kind of information is going to be stored? Is the end user aware that this chat box is a third-party chat box? We have gone and contracted OpenAI and said, we like how your ChatGPT works. Can you give us a ChatGPT extension that allows us to do A, B, C, D, E? So that is something that we talk about. We talk about by design, this thing is meant to comply with the provisions of the Act. And when you talk about by design, other than just consent, other than ensuring that the end user understands, they're also, are we just collecting the only information that we need, or are we going to collect more than we need? We only need to have a chat box to ask people to confirm if they've paid for their school fees. Then we do not need to know who their mother, their father is. We just need to have the message just indicating that this is my admission number, this is how much I have paid, and this is the number that has paid. So that is when we're talking about by design. And then in the event of default, what are the safeguards that are there? So it's by design and by default that you comply with the provisions of the Act. In the event of a default, what are the safeguards that are there to ensure that this information, even if it is leaked, does not end up compromising the privacy of many people? So you're talking about anonymization of information. And when you cannot anonymize, are you pseudonymizing? So those are very big words. But basically, what we're talking about is if we have, say, a database.
I just want you to hold on there. On the safeguards, we will pick it up from there. My director again tells me that we take our second break. So we'll be coming back to our third and final segment, where our expert will take us through further on the practical implementation and the safeguards of these principles. And also we shall have a short segment for our students who are with us tonight to put across their questions. So do not move. Let's take our second and final break and see you after that very short break.
Baada ya kutafuta kazi, tunaweza kuanzisha miradi yetu ambayo ingetusaidia kubadilisha maisha ya wazazi wetu.
Kwa vijana wenzangu, wengi hawana kazi, lakini ikiwa sisi wenyewe tutajiamini, tunaweza kujiajiri wenyewe.
Afrika kwa kweli tuna mahitaji ambayo ukiyasuluhisha unaweza kuathiri watu kwenye bara hili.
Bila woga, watu huwa na uzalishaji zaidi, wanajawa na ujasiri, wanakuwa wabunifu na wanakuwa wenye maarifa.
Niliamua kuacha kazi, hata kama sitafanikiwa, nitakuwa nimejaribu, nitakuwa najua haiwezekani.
Hakuna kitu cha ajabu hapa. Kila anayepata ufanisi hufanya kazi usiku na mchana.
Kitu kitakusukuma na kuwezesha kupata maarifa ambayo hukuwa nayo.
Tunajaribu kutengeneza kitu kitakachopita mipaka ya nchi hii.
Ikiwa unataka kubadilisha ulimwengu, anza na nyumbani.
And welcome back to the mother of all law talk shows on television, Law Matters, the show that will always put into perspective all legal concepts in order to address your views, reveals, and provide answers to your very candid questions. With us tonight, still our expert, Madam Nancy Kisangau, breaking down data protection and the law on it like it has been done before. So, Wakili, with organizations and companies that are dealing with information data that belong to data subjects, as you call them, what models do you think such organizations or entities should put together to ensure data is not used for bias or discriminatory, indiscriminatory aspects? What can be used to ensure that is eradicated?
So I'll answer that, but just allow me to finalize on our last concept. We're talking about anonymization and pseudonymization.
Yes.
Basically, those two concepts are just ensured or structured to ensure that if data is leaked to a third party, that then you don't immediately know what this information is. So you can sort of code it in a secret language that ensures that we do not explicitly know what that information is. Now, coming to how to ensure that the AI we develop does not, inadvertently lead to bias and discrimination. In most instances, as we have currently, we have a parachute model of AI deployment. So parachute model, I'd like to just talk about it. When you have a parachute, you just come into the community and you land without understanding what are the nuances about this community, what is unique about this community, what is the interaction with information. So when you're talking about bias, one of the main things and one of the main ways we can actually reduce discrimination is talking about where you get this training data from. So you'll find that most models are either built on European areas, they have European notions of data protection, of what qualifies as right and wrong. So you find that when you're coming to deploy it, say, in Africa, you're having such a difficult time because the culture is quite different. We are having different notions of what is just and what isn't just. So it's very important to sit down and consider where is the training data being obtained from. And just on the concept of data, there has been a huge push to ensure we have what we call open data systems. So open data systems means that anyone, anywhere can access this information, of course, within the right channels. But we're talking about things like national census data being obtained at any point in time. So when you're talking about the demographics of, say, a place like Nakuru, it's easier for you to be able to build up what those demographics are, as opposed to just generalizing and saying they're just Kenyans, if you're trying to build a specific provision. The second thing is skills. It's very hard for you to advocate for yourself if you're not in the room. You need Kenyans to be in the rooms where these decisions are being made, because if they're not there, then it's very difficult for you to say this is how we operate. I think one of the best examples I can give is in Kenya, the use of M-Pesa is very liberal. I think there's no one above the age of 18 who doesn't understand how M-Pesa works. But if you're to take that same concept and take it to another country, say in the UK, it's very difficult for them to understand how this works because they have a different motion, a different movement in terms of banking systems for them are more easier to understand. Then finally, we also think about having the right infrastructure to ensure that we support the skill sets and the engineers who are trying to build these models. So that is how I think we can recommend reducing bias and discrimination.
Thank you, Nancy. Now, due to time constraint, you'll allow me. I see my audience is very excited and they're burning with questions. So I'll now move to my students who are with us tonight, and they'll each ask their questions, and we'll take first 3 questions. We will answer to them. Rather, our guest will answer to the questions, and then we will have the last 2, and then we close that segment. So you can say your name. If you're a student, tell us your year of study, and then you can shoot your question. Welcome.
Law student. And my question will be with regards to the involved parties, indirectly involved parties. Like, it is in public domain that parents do have rights over minors and data, photos, or anything around that. So what happens to data? Give an example, let's say, of a photo that the child feels, not necessarily the child, a brother, a sibling, a relative, feels that it harms their reputation, for example. But the holder of that image is comfortable with it, but the author is not. A good example would be parent-child relationship. So what happens to such a scenario?
Thank you, Mr. Victor Kimathi. You'll allow we take the second question. That was Mr. Victor Kimathi. Asante.
Good evening. I am David Masinde, second year. And my question to Madam Wakilis matters consent. Now, is it really legally valid for, AI, all those AI companies placing huge and long terms and conditions, and when somebody feels that there's no data privacy, when taken to court, the court says, let's say, ignorantia legis non excusat, ignorance of the law. Yeah. So, how really is it valid if the normal and the natural man cannot really go all through all those terms without really, naturally, consenting to it?
Thank you, Mr. David Masinde. Our last question. Gender balance, very good.
Good evening. My name is Celine Awor, second year law student. My question is in light of the people in power, especially our leaders, and in reference to right to freedom of right to information and right to privacy. So let's take, for example, the governors. How do we go about it when we are seeking information without infringing on their right to privacy? Yeah.
Thank you, Celine Awor. So, Wakili can provide the answers.
Yeah, very interesting question. So I'll begin with Victor, your first question. When it comes to instances where you're having a minor or a person who can't consent, so maybe because they're legally incapacitated, unfortunately, or fortunately for the parents who are watching, it is the parents or the person, the legal guardian, who will have authority to make a decision around that. And I'll direct you to the ODPC website. There are very good cases around minors and instances where something has happened to them, maybe in school, where their photos have been taken without their consent. And we have had instances of the parents being able to represent them. Now, to the extent that a minor maybe feels comfortable with a photo, then that then becomes, unfortunately, more social than legal, because at that point in time, it's the person who has authority to consent, because minors can't consent. And trying to usurp that will actually usurp more other issues in society, as opposed to just this one segment of consent. Maybe in the future we can have structured laws that talk about consent for various age groups, but as it sits right now, as long as you're a minor, as per the law, then it is your guardian or your parent who has the authority to determine questions around consent and data privacy issues that you may have. So the second question is on AI and having long terms and conditions, and just knowing basically in most instances that it's very difficult to get the ordinary citizen to sit down and say that they fully understand what they're consenting to. Unfortunately, this is an area where power dynamics are very imbalanced. So you find that what we have is a standard form contract that can't be amended for you. So what other countries and other advanced nations, so to speak, have done is to require consent to be proven by how they design their privacy notices. If you recall, one of the things I mentioned earlier is that one of the ways you can show that the data subject truly understands what you have told them you're going to do is through a privacy notice. And what nations like the EU have done is to, and even actually one of the best examples is the Information Commissioner of the UK. What they have done is to talk about how you can structure your privacy notices to ensure the data subject truly understands what they are consenting to. So the approaches that they have recommended, things like having a layered approach to the terms and conditions and the privacy notice, having a just-in-time approach where if you're about to go into this page, then they tell you, if you're going to this page, this is how we're going to process your data. So there are certain approaches that other countries have done. In Kenya, we don't have those specific approaches. Hopefully with time, because we also have to realize that our act is very still young, we're still subjecting it to the normal pressures of the system. So hopefully with time we'll have such a guidance. But if you really want to read more about it, just go to the Information Commissioner's website and think about how they have done that. And hopefully, even when you have a client in the future someday, you can actually advise them and say, this is how this jurisdiction has done it. I think to avoid liabilities, this is how best you can also do it. Now, the last question on balancing the right to freedom of information and the right to privacy, you will notice that when you look at the Data Protection Act, when you look at the very last pages, the segments talking about how the Freedom of Information Act, the Access to Information Act has been amended. And when you do a comparative study to countries like South Africa for Popeye, they actually have specific instances where they say, when it comes to accessing information, this is how this specific provision is going to be modified to ensure that it reads it consistently with the right, not the right to privacy, but the relevant Data Protection Act. Now, it's also important to note that when it comes to Access to Information Act, and generally also just our current Data Protection Act, not everything is founded on consent, okay? So there are other areas, that's the second limb of actually processing information, where we talk about necessity, where if it is needed for a specific purpose, say for instance, for compliance with the law, then that information can't be hidden. You can't now argue under the right to privacy and say that this information needs to be hidden. So you have it's a balance that needs to be struck. Hopefully, with time, what we can do with our act and with the guidance of our legislators is to have specific provisions in the Data Protection Act that says when it comes to law enforcement, how do we then codify and talk about access to personal data, and how do we balance that against the right to privacy? I think the best guidance I can give you is go to the UK GDPR 2018. It has specific provisions on what happens if law enforcement needs to access your information, because it's not a blank pass that you have. The specific regulations and laws that law enforcement authorities have to comply with when it comes to accessing your information. But that provision is not here currently in our jurisdiction. In fact, if you need to comply with a lawful order, that is one of the bases within which your information can be processed without consent.
Thank you, Madam Nancy, for your very candid and clear answers. So we can take two last quick questions before we wrap up this segment. Yes, our fourth question.
Okay, my name is Enoch Mwanza. I'm a first-year student. I was asking this way. If I take my personal details to company X, then the company X shares my personal details with the third party. What are the rules that the Office of the Data Protection can use to protect me? And lastly, what can I expect as compensation from that? Then the last one, I was asking if the AI, can it be used as a data protection tool so that it can detect breaches of privacy if it arises?
Thank you, Mr. Enoch Mwanza. And now to our very last question.
My name is Margaret Aima. I'm a second-year student. And throughout our discussion, we've talked about the Office of the Data Protection Commissioner. And my question is in that regard. Does the office really have any progressive role so far in as far as the development of the artificial intelligence is concerned? And this is in regard to the fact that in Kenya currently, many people are using the AI, and a lot of content and information are being fed to the AI, which either could be used useful as evidence, or rather could be used to process malicious information. So does it have any progressive role or maybe future plans in as far as that is concerned? Thank you.
Thank you, Margaret Aiva. And my director, Mr. Boniface Odhiambo, is on my neck. He tells me we have strictly 2 minutes to the end of the show. So kindly, Nancy, quick answers to those two questions.
Okay. So for Enoch, if a company uses your information, the main thing you have to consider is whether you consented for them to share that information. If you do not consent, you can register a complaint to the Office of the Data Protection Commission. You can do this online through their website. There is a segment for you to file your complaint. In terms of how much compensation, normally compensation is if you sue the third party or if you sue the company. If you go through the route of a complaint to the ODPC, they normally award a fine, but the fine is payable to the ODPC. If you now want to sue them for a breach and you need to get compensation, you can take that finding from the ODPC and then have a civil suit and then get your compensation. Can AI be used as a data protection tool? I think so, but then now you remember when we talked about having specific coding, the AI tool will have to understand what the provisions of the Kenya Data Protection Act are, understand the context within which it is applied, and then you'll be able to do so. But remember, as you do so, you also have to ask yourself whether it is worth the risk to expose more personal data to that AI tool. So that is something that you have to weigh against. And then, Margaret, on the question as to whether the ODPC has progressive rules, the ODPC always, I cannot speak for them, but I do know that they always have industry-specific guidance notes that they normally issue. They may be working on one currently, so that's something to watch out for because I'm sure that is something of interest to them. Yeah.
Thank you, Madam Nancy Kisangau. Unfortunately, that brings us to the end of our show tonight. I wish we had more time for this. Perhaps I'll talk to my directors and my planners to have a second part of this show. And thank you to all our viewers for being with us tonight and to our students who showed up to be part of this show tonight. Until we see you again, same time, same day next week, I've been your host, Elvin Onsongo, and have yourselves a very good night. Thank you.